NT8 on the porch. Heads up, veterans. While all this bullshit is going on, the Democrats are trying to slip another one in on the veterans. They're trying to take away your Second Amendment rights. Yeah, they're trying to take away your Second Amendment rights. Because you were trained to kill. Just like I was. We were trained to kill. And the Democrats think, oh, we can't have this shit going on. We can't have them getting weapons. At the end of this video, I'm going to put my senator, Chuck Grassley's speech on the floor, and I'll let you listen to it. Not let you, but have you listen to it to see what bullshit Illinois Senator Dick Durbin has been since 2016, has been trying to propose. Well, you were in the military? Ah, take away your weapons. You may have PTSD. Really? Really? So let's see. How many of the military that went into law enforcement would not be able to carry guns anymore? Got out of the military and then joined the police force. Really? Can you believe these fools? But I tell you what, my senator, Chuck Grassley, stood up and called it for what it is. It's bullshit. This is what the Democrat Party will do to you veterans and me. How long's that? How's that 8 years of Democratic VA care work for you under Obama? How's it work for you? How's it working now under Trump? Oh, well, I've got a card in my pocket that says I can go any fucking place I want and get care. I'm a retired vet. So, yeah, I can go anywhere I want. But did that happen under Obama? No, it didn't happen under Obama. It took Trump to get in office to make that happen. Why did it take so long? Oh shit, I was hoping that was a spray truck, put brine on the roads. But that's looking pretty cleared off now. But anyway, I wanted you to see my senator standing up for veterans, and I wanted to get your opinions. So, NT8 on the porch. We'll talk to you later.
I would like to raise a very important issue impacting our veterans population, and that issue is a systematic denial of these veterans' Second Amendment rights. This comes up in discussion with Iowa veterans, and I have candidly discussed this issue before on the Senate floor. Today, I am introducing bipartisan legislation co-sponsored by Senator Manchin called, quote, the Veterans Second Amendment Rights Restoration Act of 2018, end of quote. And this bill is being introduced to solve a problem denying these rights to veterans. The legislation is about the fidelity of the Constitution and about the fidelity of the Bill of Rights. It is also about due process and fairness for veterans. What this is not, I want to make clear, what this is not about is allowing anyone to purchase a firearm who is prohibited under current law or regulations. I want that to be very clear. I want it to be very clear right off the bat so that no one misinterprets this as some effort to let people own firearms who would normally be prohibited. This legislation is needed because a very disturbing trend has occurred in the past decade. The Veterans Administration has been reporting veterans to the National Instant Criminal Background Check System, and that's the National Gun Ban List, just because these veterans have been determined by the VA to be veterans requiring a fiduciary to administer benefit payments. Now, this is a pretty simple proposition that denies veterans their Second Amendment rights. It's that simple, as I just said. A fiduciary administering benefit payments to a veteran could and does lead to that veteran being denied Second Amendment rights. Then once on a gun list, a veteran is outlawed from owning or possessing firearms. It is crucial to note that the regulations that the Veterans Administration's relying on are from way back in the 1970s. That predates even the National Instant Criminal Background Check System and is way, way long before the Supreme Court held the Second Amendment to be a fundamental constitutional right. These regulations grant limited authority to determine incompetence only in the context of financial matters. The regulation reads like this, quote, "Rating agencies have sole authority to make official determination of competence or incompetence for the purpose of insurance and disbursement of benefits," end of quote. Now, there's nothing wrong with that language, but it's that language that leads to the problems that veterans have with their Second Amendment rights. So from this language, it's clear that the core regulatory authority applies to matters of competency for financial purposes. It has nothing to do with regulating who can purchase firearms, but that is exactly what is happening. So veterans are losing their Second Amendment rights because they have someone managing their checkbook. It's that simple. You can't handle your finances, you lose your Second Amendment rights. So everybody wants to know how this is happening. Federal law requires that before a person is reported to a gun ban list, they be determined a quote-unquote mental defective. The Bureau of Alcohol, Tobacco, and Firearms created a regulation to define what mental defective means. It includes, among other requirements, that a person is in danger to self or others. The VA has taken the position that this alcohol, tobacco, firearm regulation can then be made to fit within its own pre-existing regulatory structure for assigning a fiduciary, thus requiring that name be put on the gun ban list. The intent and purpose between these two regulations are entirely different. On the one hand, the VA regulation is designed to appoint a fiduciary. On the other hand, the ATF regulation is designed to regulate firearms. That is a great, big, huge distinction. The level of mental impairment that justifies taking away the right to possess and own firearms must rest at a severe and substantial level, a level where the mere possession of a firearm constitutes a danger to self and others. That decision is never made by the VA before submitting names to this gun ban list. As such, then, imposing a gun ban is a harsh result that could sweep up veterans that are fully capable of appropriately owning a firearm. And in fact, it gets worse. When veterans are placed then on that gun ban list, they must prove that they're not dangerous to the public in order to get their names removed from that list. That dangerousness standard is much higher than the mere assignment of a fiduciary. Thus, veterans are subject to more rigorous and more demanding evidentiary standard to get their names off the gun ban list than the federal government must prove to put their names on that list. So, we ought to all agree that that's patently unfair. And I also believe that it is unconstitutional. When dealing with a fundamental constitutional right like the one protected by the Second Amendment, at the very minimum, the government ought to be held to the same standard as we, the people. We owe it to our veterans to fix this problem. As of December 31st, 2016, the Veterans Administration reported 167,815 veterans to the gun ban list for assigning a fiduciary. That's 167,815 out of 171,083, or another way of saying it, 98% of all names reported. It is important to note that since the VA reports names to the gun ban list merely when a fiduciary is assigned to that veteran, not one of those names has been reported because a veteran has been deemed a public danger. Accordingly, not all veterans reported to the gun ban list should be on it. On May the 18th, 2016, I debated this very issue on the Senate floor with Senator Durbin. He said, and I quote, "I do not dispute what the senator from Iowa suggested, that some of these veterans may be suffering from a mental illness not serious enough to disqualify them from owning a firearm, but certainly many of them do," end of quote. Then Senator Durbin said, quote, "Let me just concede at the outset, reporting 174,000 names goes too far, but eliminating 174,000 names goes too far." I'm pleased that Senator Durbin acknowledged that many of the names on the gun ban list supplied by the VA do not pose a danger and should be removed. I want to thank his staff for working with my staff during this process. The essential question then is, how do we go about fixing it the right way? And I believe my legislation does just that. This legislation adds a new step before the VA can report names to a gun ban list. That step requires that once a fiduciary is assigned, the VA must first find the veteran to be a danger to self or to the public before taking away their firearms. That's the same standard that the veteran must satisfy currently in order to get their names off the gun ban list. My legislation also provides constitutional due process. Specifically, it shifts the burden of proof to the government to prove a veteran is dangerous before taking away firearms. Currently, the entire burden of proof is on the veteran to prove that he or she is not dangerous. When a constitutional right is involved, the burden must always be on the government. My bill also creates an option for the veterans to seek legal redress via administrative board or the federal court system. The veteran is in control, and it provides an avenue for every veteran already on that gun ban list to get their names removed. That last point is important to note. My bill does not automatically remove every veteran from the list, which was a concern Senator Durbin raised previously when we debated this issue. It does require the VA to provide notice to every veteran on the list of their right to go through the new process to have their names removed. Should a veteran choose to do that, the protections, the process, the procedure, and the standards set forth in my bill would then apply to them. Every veteran is free to apply for relief. Every veteran will be treated equally under my bill, and of course that's a fair thing to do. That's the constitutionally sound way to manage this process. The bill does provide authority for the government to seek an emergency order if they believe a veteran is a serious and imminent risk to self or to others. That was a suggestion by Senator Durbin to provide for a short-term safety mechanism when the situation is too urgent to wait for a judge to evaluate all the facts. The bill also retains a mechanism for the VA to systematically refer veterans to the National Institute Criminal Background Check System. This was another one of Senator Durbin's main concerns. A similar bill and simpler bill passed the House of Representatives last year that is similar to the amendment I tried to offer and Senator Durbin objected to in the year 2016. It would simply stop the VA from referring veterans to the gun ban list without first finding them a danger to self and others. However, it did not set up any system to make that happen. The argument is that this puts veterans using the VA in the same boat as somebody else, and of course I'm sympathetic to that argument. But the legislation I'm introducing today was a good faith effort to overcome objections that have prevented action on this important issue in the past. My bill solves a problem that has existed for many years, denying veterans their Second Amendment rights. Veterans should not be subject to a harsher standard than what the government is subject to. Veterans deserve full due process protection when their constitutional rights are at stake. And that's the core of this legislation. The regulatory process at the back end to remove a veteran from the gun ban list is simply moved to the front end. That is, the federal government must first prove that a veteran is dangerous before taking away firearms. This is the same standard applied to non-veterans. This fix will not change existing firearm laws. Felons are still prohibited from owning firearms. Persons with domestic violence convictions are still prohibited. Persons adjudicated as mentally defective are still prohibited. Persons involuntarily committed are still prohibited. If my bill were to become law, every federal firearm prohibition would still exist. Again, the core of my bill simply requires the federal government to prove a veteran is dangerous before taking away his or her firearms. That's the same standard our veterans must live by currently in order to remove their name from the gun ban list and get their guns back. If we, the people, have to live under that standard, then so should our federal government. I yield the floor and suggest the absence of a quorum.